You're tuned in to Agriculture Today, and we start our Wednesday show with an agricultural law update, and we're joined with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
Roger, today discussing hunting agreements, and on the subject of hunting, important to mention that turkey season is not happening this year.
Yeah, that's an interesting one. I guess it's happened at least one time before, but that is certainly unusual.
As we continue to talk about hunting, something important, hunting agreements of using other people's land. And first off, how all wildlife is public.
Yeah, that's right. And when we talk about hunting agreements, now most people will probably roll their eyes and say, well, we really don't enter into a hunting agreement. And that's true. Most people don't. It's just orally granted permission, or sometimes if there's no permission that's granted, then it's a trespass. But there are some important things that we need to keep in mind, and it might be the best for a landowner that wants to have hunters on their property to execute a written agreement. But the first thing that we need to discuss, as you mentioned, is what is the property interest that's involved. And the state does own all of the wildlife in this state, whether it's animals or fish or fowl. As long as those are not privately owned, then they are owned by the state, and that's specified in state law. But that doesn't mean that you can just go on somebody else's land and take whatever belongs to the state. As a hunter or somebody that's an outdoorsman in general, you don't have any right to go onto somebody else's property to hunt and fish without first getting permission. And of course, if you do that, that could be a civil trespass, or you could get prosecuted for a criminal trespass for an unlawful entry that violates the hunting provisions in Kansas.
And there is a small caveat for allowing outdoorsmen to go onto someone else's property.
If you're out hunting and you have permission to hunt either verbally or by an agreement, and the game that you're hunting, you wound it and it strays onto somebody else's property where you don't have permission for hunting purposes or any other purposes, state law says that you can track that animal and you can go in there and you can get that game and capture it and get out of there. But there's kind of a caveat to that. Kansas law says that such a person that does that, if the landowner of that land requests them to leave, they are to leave. And so I think the best approach for the landowner in that type of situation is just to call the sheriff and never, ever personally try to force the trespasser off the land with threats of physical violence or at gunpoint. That is a big no-no.
And talking about people being on each other's land, for farm tenants, they have the right to hunt, and if the landlord wants to, they might need to put that in writing.
Yeah, that's another thing about an oral farm lease that we would like to get in writing and specify, just to make sure we're clear on these things. Because when a tenant takes possession of the property that's under the lease, the tenant has possession for the term of the lease, and that right of possession cannot be interfered with, even by the landowner. So unless the landowner reserves the right to hunt the land that they own that is under a lease to somebody else to farm it, they can't hunt on that property unless the tenant gives them permission. Now, there's a practical aspect to that, and that is if you don't have a written farm lease and the landowner wants to hunt their ground and the tenant says, no, you can't, it's very likely that that's going to go a long way toward deterioration of that relationship between the landowner and the tenant. The tenant's going to become a short-term tenant because they'll get notice to terminate. So it's always best, I think, to get hunting rights reserved in writing if the landowner wants to make sure they can hunt their property and it meets with all the parties' expectations.
Roger, in the terms of getting things in writing, another important place is maybe attaching a map to those agreements.
Yeah, I think if you're going to sit down and put together a hunting use agreement, then there are certain elements that you have to have. And one of those would be a legal description and a map. And I think that's absolutely essential to include a description of the property that the hunting operator, and that's how we typically define that, may hunt. So give the number of acres, give a general description of the property, and then provide a precise legal description of the property and attach that as an exhibit to the agreement. I think it's also a good idea to provide a map showing any areas where hunting is not allowed and attach that map also as an exhibit to the agreement.
And for those people who are hunting, the hunting operator's right to use the property exclusively or non-exclusively.
Yeah, we need to be clear whether the hunting operator's right is exclusive or not. And if they're granted an exclusive hunting right, that means it's exclusive to them alone. The landowner then would not be entitled to use the property for game hunting purposes during the term of the agreement. And if I want to reserve the right to do so, I need to reserve that in writing. Well, if I don't have a farm lease, I need to make sure that we're clear as to whether I can hunt my own land while I have somebody else hunting that property. So if I've granted an exclusive right to the hunter, then I can't hunt my own land at the same time. If the hunting operator's right is non-exclusive, then I, as the landowner or anybody that I designate, is entitled to use the property for the same purposes of hunting wild game. So if I've got a non-exclusive right, I think it's desirable to list any limitations to the landowner's retained hunting rights in that situation too. So let's be clear on who has what rights and whether they can be interfered with or not.
And another thing that might need to be included in writing is specific dates and times for those hunting operators.
You want to specify when the hunting right begins, when it ends, and I think you want to denote the property that can be used for game hunting purposes, that you're going to limit that to legal hunting seasons and hours tied to the particular wild game at issue. Don't extend the hunting operator's rights beyond the applicable hunting season.
And we mentioned talking about what's allowed and what's not allowed and where they're allowed to be, but what if improvements or changes are made on that hunting property?
We want to put a specification in there as to whether the hunting operator is given the right to construct improvements on the property. And what I mean by that, the big one on that one would be to put up a deer stand. And if so, what are the rights to be desired? So think that through and be clear on it. Is the landowner obligated to construct any improvements? For large hunting operations, the landowner commonly constructs certain improvements such as new roads and fences and gates and hunting camps and wildlife crops and feeding facilities and blinds and tree stands and so forth. Those are for your big ranching operations that have thousands and thousands of acres, and they operate it as a dude ranch, and they have scheduled hunts on there. And often the operator does put improvements on the property. Also, in line with that, give some thought to including a provision in the agreement for the cleaning and repair and maintenance of those improvements there. Which party does what? If
the landlords don't want certain things on their property, that also needs to be written in the lease.
Yeah, clearly state what uses on the property are not allowed. One would be campfires. We don't want to start a prairie fire someplace. What about the use of dogs? What about camping overnight on the property? You know, you get further out west, it's not so much in Kansas, but out west, you get into Colorado, are pack animals going to be used? If so, then you need to specify that the animals have to be in compliance with any applicable branding or other identification requirements. So as you move further west and the type of hunting changes, then we get different types of agreements, or you get down into Texas, for example, and the big ranches, different types of game than we might have in Kansas. Those are issues that need to be addressed, plus the driving of vehicles. Are you restricting the use of vehicles to particular areas? And if gates are going to be driven through, you want to put a provision requiring the hunting operator to be responsible for leaving the gates in the condition they found them in, whether that's locked or unlocked, for example.
And a lot of landlords might be doing this as an additional source of income. So how could they go about finding what's the correct amount to maybe require for payment?
Yeah, that's a tough one. The answer to that question, I think, is going to depend upon the rates charged for similar properties and game in the area. So you want to ask around and see what others are charging. But that's going to be pretty difficult to determine in most circumstances. There might be data that's available someplace. So sometimes extension services will have that. I know particularly out west that there is that data that's readily available, but people want to check with the local extension office to see if that information happens to be available. County extension agents might be a good place to start on that one.
And another portion, keeping everyone safe is important, and part of doing that is liability.
Liability is a big issue. First, you want to make sure you have adequate insurance coverage to cover whatever activities are going to be occurring on your farm or your ranch. And that's a very important aspect of any fee-based activity on your farm or ranch. And the agreement, the hunting use agreement, should specify which party or both is to maintain liability insurance coverage and the amounts of the coverage. But make sure the insurance covers any improvements on the property. We talked about improvements. And so if there are improvements, that's another issue that needs insurance coverage. And don't rely on coverage under your existing comprehensive liability policy for the farm or the ranch. There's probably an exclusion in that policy for non-farm business pursuits of the insured, and that's what this would be, particularly if you're being compensated. If you're being compensated for this, if you're charging for somebody to hunt on your property, that's going to fall within that exclusion, and your general comprehensive farm liability policy won't cover it. So you've got some things to talk about with your insurance agent to make sure that you're adequately protected.
Are there sometimes state laws that interact with liability because of agritourism and recreational use statutes?
Kansas, just like about every other state, has a recreational use statute that's designed to provide liability protection for farmers and ranchers that open their land up for recreational purposes. Now, if you charge a fee, do you get the protection of the statute? Technically, the statute says that in Kansas, but it's never been tested in court. So I really wouldn't want somebody to be the first test case on that one for fear that the court might say, well, you're profiting from this, therefore you lose the protection of the statute. But basically what the statute does is treat an entrant for recreational purposes on a farm or ranch as a trespasser. And so you don't have any heightened duty of care that you owe those persons. So your liability potential goes down. It's not non-existent. You can still get sued and get hauled into court, but it might provide some protection in the right situation.
That was K-State and Washburn law professor Roger McEowen. I will link the article in today's show notes, which you can find on agtoday.net.